Welcome to Wills, Estates, and What Comes Next, Probate Insights with Jamie Cuzmar.
Welcome to Wills, Estates, and What Comes Next, the podcast where Florida families get clear, compassionate guidance through estate planning and probate. I'm Sophia Morales, and I'm here with attorney Jamie Cuzmar, founder of Cuzmar Law Firm. Whether you're planning ahead or navigating the legal process after losing a loved one, this show is here to make complex topics feel understandable and manageable. So let's get started. Welcome back, Jamie.
Hey, Sophia, good to see you.
So today we're discussing Beyond the Binder, planning for the people you love. So tell us why estate planning is really about protecting people, not just distributing money.
Yeah, so other than distributing money or assets, estate planning goes beyond that in that it's fundamentally about safeguarding the well-being of your loved ones. So again, beyond the assets, it's really about, is your family going to be better off by doing this planning ahead of time? So by planning ahead, you ensure that your family is protected from potential legal disputes and financial hardships in some cases, like avoiding probate for that matter. It's also about providing peace of mind, knowing that your wishes will be honored and that your loved ones will be cared for in your absence.
How do you help your clients think through who should make decisions for them after they've passed or in an emergency?
So, helping clients choose the decision makers for emergencies involves thoughtful considerations. So, considering what the values and the relationships of these people and how they play a role in this decision making process, right? So we have to guide them through evaluating who they trust to make critical decisions, like raising their children should they not be around, like in guardianship, who understands their wishes and who can handle that responsibility. So really it's about ensuring that the chosen individuals are capable and willing to act in the client's best interests during these challenging times.
Do you recommend that they have conversations with the people that they're considering to kind of get a feel?
Yeah, definitely. That, of course, makes for a better plan. There are some families that don't want to have those conversations, but I will try to urge them, say, hey, look, it's better if you tell them, yeah, you can name somebody, say, for example, as a trustee or a power of attorney. But if you don't mention to that person, hey, I have elected you in this role, they have the ability to back out. They don't have to take on that role, especially if they weren't informed of it. So definitely it's very important to have that conversation ahead of time so that the expectations could be set out and to give the other person kind of an understanding of what the role really involves and then give them that due diligence to make the decision that, yes, they're okay with that.
Yeah. Well, and I think it's kind of easy to go, well, I'll just have this person do it, but then we don't consider how difficult it might be for that person to do it.
Yeah.
Thinking
And
about
then
like a healthcare power of attorney where you're making decisions about, do we withhold care? How much intervention do they want? This sort of thing.
Yeah. And in the guardianship nominations for children, for example, it is required that they inform someone outside of those guardians that they've named, just so that there's other parties aware that they've named this person as a guardian. And that also helps keeps the conflicts to a minimum as well. So say you have two sisters and you name one sister as a guardian of your kids and not the other, it's very important to tell the one that you didn't name just so that they're not caught off guard either.
Yeah, well, true. And do you do like a guardian A and a guardian B? Because I know stuff evolves as you go down the road, right? And maybe Sister A, who you preferred, uh, runs into some trouble in the meantime where she doesn't feel like she can take on the kids anymore.
Yeah, so definitely in most of the planning, we will name contingencies or a second choice. That way, you don't have to redo the documents just because something happened to your initial choice. So you can name multiple backups. You can have even co-trustees, for example, make it so there's the checks and balances. Name both parties as co-trustees if you have an issue there where, or a concern there where you think one of them might not do things properly. They don't have checks and balances, so to speak. But definitely, contingencies are very important. And I tell those people that if they don't have, for example, a lot of family, a lot of times people don't even know who to leave their assets to or who to name as a beneficiary. And that's sometimes surprising, but you got to understand that some people outlive the rest of their family and they're the last in their line of a family member. So in that case, we will talk about maybe friends or other people in the community that they can leave the stuff behind to. There's also organizations out there that will manage assets for others or even receive charitable contributions in the form of an inheritance that they had nowhere else to go. So those things are come up quite a bit. And of course, before I even started doing this kind of planning, I wasn't aware. So it's very nice to give these clients and potential clients this information and be a guide for them when the time comes to make these decisions.
So, what do you say to someone who's uncomfortable talking about death or incapacity or what they want done if they're unable to make their own medical choices, that sort of thing?
Yeah, so you have people from all different walks of life, and discussing death or incapacity can be uncomfortable. So it's almost like a 50-50 chance that somebody doesn't like talking about it. Some people are very open, other people think that they'll bring it on by broaching the topic, but it's crucial to have that conversation to ensure that your wishes are respected. And what we do, or what approach we take, we broach the subject with sensitivity and empathy, of course, emphasizing the importance of planning for the unexpected. And by framing it this way with empathy as a way, to protect and care for loved ones, then we usually help the clients see that there's value in having these conversations and making the informed decisions. But again, every case is a little bit different.
Yeah.
We keep tissues handy, of course, in the meetings. It's not really, I say kind of in a laughing manner, but certainly there's times when that's necessary, and we take it all very serious. Some family members take a few weeks to get the other person in the door, or a spouse that some cases will have a married couple trying to do the planning. One of them wants to get it done, and the other person just doesn't want to touch on the subject because, again, from either religious beliefs or superstitions they may have. But eventually they come through and they see the importance of leaving their family members or the loved ones behind in a better position.
Yeah. Well, and I think the focus on the caring for the people you're leaving behind is probably a better focus than what to do with my stuff
Yeah, yeah,
in
that's for
terms of
sure.
opening that conversation.
But I'm definitely pleasantly surprised and hopeful with the generations coming about doing their planning now. Even younger generations, I have some families and some couples in their 20s that have gotten their estate plan done already, which is I never expected, right? But it's
Yeah.
nice to see that people are waking up to the idea that estate planning is just not for the well-to-do or people with a lot of money. It's also for the middle class, and even if somebody wants to just leave a will behind, if they don't have much, but they want to have maybe their burial wishes honored, as simple as putting that in writing in a will can take care of that.
So when you're looking at the estate planning process, where does child guardianship planning kind of fit into this?
Yeah, child guardianship planning is a vital aspect of estate planning if you have minor kids, of course. Kids that are already grown and adults, that's not necessary. But ensuring that your children are cared for by trusted individuals if something happens to you, say, in the next couple of days, I tell the scenario, or I share this scenario. Hey, I know that maybe your kids are teenagers, maybe they're 13 or 14 years old, so you don't really have that much more to go, or more years before they're adults and make decisions on their own. But assuming worst case scenarios, let's say something happens on the way home, where would you like to see your kids go, and who to take care of them? Who do you see yourself entrusting your young adults or young children, I'm sorry, with this important role of raising them the rest of the way? So we help clients designate guardians who align with their values and parenting style. So we have that conversation to help provide them peace of mind that their children will be in good hands. So we also ask about religious beliefs, dietary standards, So this planning integrates seamlessly into the broader estate process, ensuring that your protections are comprehensive for not only you, but for your young children.
And do you recommend talking to the kids about who they will be going with if something were to happen with you?
Yeah, I do. Well, it depends on the age of the children. If they're old enough to understand the situation, it's kind of a balancing act. I don't talk to the minor kids directly, but I will tell the families or the parents, maybe what to mention. But that is something that I leave to the parents to decide how to have that conversation with their young children. Older kids in their teenage years, and of course, yeah, sometimes the families will bring them along during the planning process, and we'll have the conversation with them. But yeah, little kids, that's at the discretion of the parents and how they want to mention that or bring that up, because sometimes they're not going to really fully comprehend what that entails, but they certainly want to at least know that the people they're thinking of naming guardians, that they get along with their children. So maybe something like, "Hey, do you like Uncle Johnny, or do you get along with Uncle David?" Something like that along
Yeah.
those lines. Bring it up, or at least observe how they get along with your children before naming them guardians.
So, talking of children, we have a lot more blended families in society nowadays. How does estate planning intersect with the blended family, stepchildren, and other complicated family structures that we're seeing nowadays?
So, estate planning for blended families and complex family structures requires careful consideration, because there are different rules and different laws for such situations. So, I have a blended family of my own. And when I say that, I mean I have a stepdaughter and my wife has a stepson. We each had a child before we got married from different relationships. So considering each individual's needs and the relationships, are important. Story I tell clients all the time is, hey, imagine you have a stepchild and their primary parent passes away, and then all of a sudden the only survivor is the step parent. In that scenario, sometimes there's animosity because the stepchild doesn't want to necessarily wait for the step parent to pass away before being able to inherit anything.
Right.
So one of the things that I will recommend a lot of times is do a gift or a payout directly to that child when their main parent passes away, to give them something or leave them something behind, and not requiring that both parents or both parent and step parent pass away before that child being able to inherit something. So a prime example is life insurance. It's very easy. You'll have a maybe $1 million policy between you and your spouse, and you can dictate a percentage of that to go directly to somebody if you should pass. Instead of having it 100% go to your spouse, you can have say 10, 20, 30% go to one of the children, of course assuming they're of age and are when the payout happens they're an adult, so that they don't have to wait behind for the step parent. And then of course that keeps the families a lot more in a good standing, right? Because for example, in my planning of my own, I have a good chunk of change going to my firstborn son, and not making him wait for his stepmom to pass away to be able to inherit something. So that I think works, and it'll keep the family structure more intact, and at the very minimum keep the animosity to minimum.
Yeah, well, and you never know what's going to happen with that surviving step parent. I mean, they could go on to remarry, and other things could come down
Yeah.
the pipe that would like derail what they might have gotten when that person passed.
Yeah, no, that's very true. I mean, think in cases of a revocable trust, a surviving parent will normally have the right to amend that trust and totally take out somebody if they wanted to as a beneficiary. They can redo the beneficiary designations. They can change the asset mix or the percentages even. So that is one thing that we discuss with families that have stepchildren. I give the family or the parents a choice whether you want to allow your surviving spouse to make amendments, or do you want to lock it down once one of you passes versus both of you passing.
Yeah. So, what happens if someone names a person who turns out to be unfit or unavailable in their plan? Does that get corrected, or can that get corrected?
Yeah, so if an unfit or unavailable person is named in an estate plan under the various positions or responsibilities, it can be corrected through legal amendments. So, depending if it's a will or a trust, there's different terms. So, a will normally, to amend it, is called a codicil.
Mhm.
So you can do that for wills, and for a trust, you can also either revoke the trust and redo it entirely, or we can also do an amendment to the trust itself. So we assist the clients in reviewing and updating their plans to ensure that the individuals are capable and willing to fulfill those roles. And that's one of the things that we pride ourselves in offering, is a free yearly review for our trust-based clients, just to have that conversation and review those choices on a yearly basis, just to make sure that the people designated still fit their best interests.
This looks to be a very technical legal process with a lot of ins and outs and loopholes. How do you personalize that? How do you bring humanity into that process?
Bringing humanity into the legal process involves understanding and addressing the emotional aspects of estate planning. We also prioritize compassionate communication. When I speak to the clients at their level, how I find them when they come in. Sometimes they're already distraught. Other times they're, planning for 50 years down the road, and they're, in a positive mood at the moment. But actively listening to the client's concerns and providing personalized guidance is one way where we can kind of handle that and bring the humanity piece into it. So again, by focusing on the human element, we make the process more relatable
Yeah.
and less intimidating. Also ensuring that clients feel supported and understood.
Thank you for sharing all this information today, Jamie.
No problem. It's my pleasure.
And thank you for listening to Wills, Estates, and What Comes Next. For more information or to get in touch, visit kuzmarlaw.com. If you found today's episode to be helpful, be sure to subscribe, leave a review, and share it with someone you care about. And we'll catch you on the next episode.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.